Hi, everybody. My name is Sarah Dorr. I am ISA's Director of Professional Development. I'm here today with a panel who's going to talk about the genocide question before the International Court of Justice. Just a few housekeeping things. Guidelines, if you would like to ask a question, please place it in the Q&A feature, which has been enabled. The chat is also enabled, but we will be taking questions only from the Q&A section. Each speaker will talk for around 12 minutes, and then there will be an opportunity for discussion at the end. So with that being said, I am going to turn it over to Kathy.
Hi, everyone. My name is Kathy Barrett, and I'm your moderator for today. This webinar will critically examine the evolving jurisprudence of the ICJ on the genocide question. More specifically, participants will analyze the subjective and objective cases, discuss the relationship between the ICJ and the ad hoc International Criminal Tribunals, and consider the implications of these developments for the pursuit of international justice. Although they will be mentioned, this is not exclusively about either Gaza or Russia. We have 5 participants today, each of whom will give a 12-minute presentation, followed by a Q&A session. Please put your questions in the Q&A box. You can find it down at the bottom of your screen. Let's get started. Our first panelist is Dr. George Andreopoulos. Dr. Andreopoulos is Professor of Political Science and Criminal Justice at the City University of New York and Director of the Center for International Human Rights. He will be addressing the case law related to genocide. Dr. Andreopoulos.
Thank you very much, Kathy. And first of all, let me begin by thanking thanking ISA for agreeing to our proposal to organize an event on this important issue area, and also to thank all of you for being with us this late morning, afternoon, whatever your time zone is. My remarks are going to focus on the cases that the ICJ has addressed relating to the conflict in Bosnia Herzegovina, and I will also make a few comments about the ongoing case of Gambia versus Burma. I will be using this term to describe the country, not Myanmar. And also I will conclude with a few comments about the political implications of these cases. Let me begin by saying in general that one of the controversies surrounding genocide is whether its commission requires an underlying genocidal policy by a state or some other type of organized authority. The definition of genocide does not expressly require the existence of such a policy, though certain commentators have argued in favor of the necessity of a contextual element. This view also finds support in the elements of crimes of the International Criminal Court, according to which the conduct in question must take place, and I quote, in the context of a manifest pattern of similar conduct directed against the group. However, others dispute this assertion, and it is important to note in this context that while the first 2 objective elements of the crime can be performed by individual without the context of a genocidal policy, the remaining 3 are most likely to occur when carried out on a large scale and by a group of individuals in pursuance of a common plan. Now, moving specifically to the first case, relating to the conflict in Bosnia Herzegovina, the Bosnia Herzegovina versus Serbia and Montenegro case. Here in this case, the ICJ construed Article 1 as including an obligation for contracting parties to refrain from engaging in genocide, not just prevent and punish. This reading, I would argue, is consistent with the object and purpose of the convention, and it is important to remember that the Genocide Convention is both an international human rights law as well as an international humanitarian law instrument. Some commentators, however, have argued against this interpretation. In their view, Article 3 of the Convention imposes an obligation on the state to prevent and punish genocide by individuals, be they state officials or private entities, but as far as state responsibility is concerned, this can only arise in the context of a breach of the customary rule of international law obliging states to refrain from engaging in genocide as a conduct involving a genocide policy. I would argue that you could see this view reflected in the report of the International Commission of Inquiry on the Darfur crisis. Now, turning more specifically on an issue that ran through all the cases I will be discussing about, and it is the very critical issue of establishing special intent in the case of a genocide, the dolus specialis. In the Bosnia Herzegovina versus Serbia and Montenegro case, the court concluded that the dolus specialis had to be shown by reference to particular circumstances on the ground, unless a general plan could be convincingly demonstrated to exist. The court concluded that only the case of Srebrenica met the high threshold of dolus specialis, indicating a pattern of conduct to be accepted as evidence of its existence that indicated that it could only point to the existence of such intent. That is basically, that was the only interpretation that you could give for the behavior of the perpetrators in this context. Citing its earlier jurisprudence in Nicaragua versus US, the court concluded that in order for the actions of the Republika Srpska or the VRS to be attributable to the Federal Republic of Yugoslavia, the evidence should demonstrate that they were either organs of the Federal Republic of Yugoslavia in the sense of complete dependence on the states, or under its direction and control. And the standard that they used was the effective control test. We should contrast this to the ICTY's appeal court's finding of a different test, the overall control test in the Tadic case, that led to the finding that the conflict in Bosnia-Herzegovina continued to be an international one, not a non-international one, even after the JNA forces pulled out of the country in May 1992. In my view, the court here missed an opportunity to explore the relevance of the overall control test by indicating that it is only relevant in determining the nature of the conflict and not state responsibility. And this is, I would argue against that. I think the overall control test should also be considered when we're discussing state responsibility. Likewise, in the case of Croatia versus Serbia, the court again set very high the standard for a finding of dolus speciali. It indicated that it is necessary, that it is the only inference that could reasonably be drawn from the acts in question. More specifically, while the court concluded that the actus reus of genocide had been established as a result of the killings carried out by the JNA and the Serb forces in several localities in Croatia, they were not committed with the intent to destroy the Croats. In a nutshell, the issue of dolus specialis was in the case of the Croatia versus Serbia, in discussing the dolus specialis, the ICJ concluded that Croatia had not established that the only, and I quote here from the court's decision, the only reasonable inference that could be drawn from the pattern of conduct it relied upon was the intent to destroy in whole or in part the Croat group. And a similar, of course, finding was in the counterclaim of Serbia versus Croatia. Now we see this resurfacing again in the case of Gambia versus Burma. And what is interesting is that the genocidal intent, as expected, figured prominently in the oral observations before the court in Gambia's request for provisional measures. As we all know, the case so far has, a decision has been issued only on provisional measures. The decision on the merits is still pending. During the oral observations, the agent of Gambia referred to the reports the report that was presented was produced by the International Fact-Finding Mission on the situation in Myanmar. That's the official name, of course, the commission. He referred to the report's 7 specific indicators of genocidal intent that are drawn from international case law. I will not identify or discuss this, but I'll be happy to do during discussion. In the case of the special intent, the agent for Gambia cited this report's finding that there is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct. That argument was a response to Berman's counsel argument that even if genocidal intent could be inferred from the conduct, that this was not the only plausible inference that could be drawn. And of course, he cited the court's finding in the Croatia versus Serbia case. I would argue that Berman's argument on this front was problematic. Even it is possible for another inference that could be drawn, for example, that some actions of the Tatmadaw troops were constituted crimes against humanity, as opposed to genocide. This did not mean that the court could not order provisional measures. As the agent for Gambia correctly, in my view, noted, plausibility is not a zero-sum game. The plausibility of the commission of crimes against humanity does not exclude the possibility of the commission of genocide. And this is one of the differences between the provisional measures and the merits phase. And I think that that was a positive development on the part of the ICJ, because if the ICJ had accepted Berman's argument, it would have rendered it exceedingly difficult for the court to order even provisional measures in cases where the commission of genocide was alleged. I would like to conclude very quickly, because I see I'm running out of time, with some of the political implications. I think, of course, judges always say that they think only and act according to the law. Of course, we don't know what is in their heads, but they are part of an international process that has both political and international and political as well as legal dimensions. The restriction of the finding of genocide to Srebrenica and the failure to prevent it and punish it raised the bar, and this has legal as well as political ramifications. The legal, I have already briefly discussed it, was the fact that it created a very high bar that will be used as incentive by other states to block provisional measures in the future, as Burma unsuccessfully tried to do when the pleadings were were taking place concerning the provisional measures. The context of the Bosnia-Herzegovina decision must be looked within the broader debate and effort of these countries to accede to the European Union. And it was a decision that I would argue was intended to minimize any collateral political judgment damage to this process of accession. Croatia is already part of the EU. Serbia remains a candidate member. Finally, on the case of the Rohingyas, what we have, unfortunately, is a deadlock at the Security Council, a deadlock at the regional level, ASEAN. So the only possibility, unfortunately, for protection, any protection for the Rohingyas, could come from the International Court of Justice, which, although it is symbolically important, it will it is highly unlikely that it will improve their condition on the ground, especially bearing in mind that the decision on the marriage case will take years to materialize. I will stop here and I'll be happy to answer any questions. Thank you.
Thank you, Dr. Andreopoulos. Our next panelist is Dr. Miao-ling Hasenkamp. Dr. Hasenkamp is a senior research fellow at the Center for Eurasian Studies and Institute for Political and Administrative Sciences at Rostock University. Her expertise ranges from international human rights politics, comparative governance research, law and culture, to public policy analysis, particularly in the nexus between security, human rights, public health, development, and migration. Dr. Hasenkamp will be addressing the interaction between the International Court of Justice and the International Criminal Tribunals. Dr. Hasenkamp?
Thank you for Kathy's introduction and for having me to join this interesting webinar. My presentation will look at how the idea of universal jurisdiction has guided the International Court of Justice proceedings, including its attempt to go beyond the strict interstate dimension, help construct an atrocities regime, including the ad hoc international criminal tribunals, and encourage national courts to prosecute genocide by creating new institutional options to overcome the gaps between ideal politics and real politics. I focus on some historical, political, and legal elements of the court's role and the role of the victims' voices within the prosecution process in several ad hoc international criminal tribunals and national courts, and their implications for the court's future work. To start, I would like to share with you two thoughts expressed by two judges of the International Court of Justice. By referring to the activities of the two judicial institutions of the UN, Judge Peter Tomke once said that hopefully the activities of International Court of Justice, as well as the ICTY, International Criminal Tribunal for former Yugoslavian, contribute in their respective fields to their common objective, namely the achievement of international justice, however imperfect it may be perceived. Secondly, by referring to the case or the ruling of the Gambian versus Myanmar, as George had just mentioned, Judge Concedo Trinidad said in his separate opinion of the judgment in January 2020. He said this case requires the ICJ to go beyond exactly the strict interstate dimension and to concentrate attention on victims, including potential ones, be they individuals, groups, or groups of individuals, peoples, or mankind, a subject of international law, and not on interstate susceptibilities. Human beings, he continues, invulnerabilities are the ultimate beneficiary of provisional measures of protection. In light of these two thoughts, I have two main arguments. First, avoid all structural and political constraints. Since its first landmark rulings, Bosnia and Herzegovina versus Serbia in February 2007, as discussed already by George, the court has demonstrated its commitment to supporting ad hoc tribunals such as the tribunals for Yugoslavia and Rwanda. The methodology and interpretative subtlety adopted by the court not only have strong implications for future cases, the rulings also reveal an emerging dependent relationship between the court and the work of other and future criminal tribunals, whose essential texts have been to examine exactly the states of mind of senior officials to determine if genocidal acts were committed with the intent to destroy a protected group. Secondly, building upon my first argument, the court increasingly face faces political, analytical, and interpretative challenges arising from the recent proceedings and older activities found in the cases of Gambia versus Myanmar, as well as South Africa versus Israel this year. Several questions emerge, for example, concerning require careful examination concerning new dynamics of political and legal developments. They include the identification and proof of specific intent of a state in the crime of genocide, as George had just mentioned, the consideration of victims' voices and reflections upon the standard of evidence found in its case law rulings. They might push forward the court to rethink its role in the UN system, to carefully examine the competing authoritative legal basis, including also the voices of the UN Legal Council, and to explore its potentials in finding adequate provisional options to create a facilitating environment. That's what I think it's very important for the court for resolving those situations that completely violate the international humanitarian and human rights laws. Let's first consider the role, court's role and its relationship to the ad hoc tribunals and national courts from historical, political, and legal perspectives, respectively. Firstly, it must be said that although the court judgment provides no precedential values, those judgments are treated as authoritative by international lawyers throughout the world. A brief history review of the development and function of the court shows that the court has begun to carefully use subtle methodology and techniques to deliberate its provisional measures reasoning, such as the inclusion of the extreme human vulnerability in its 2020 Gambia versus Myanmar ruling. As such, the court has signaled to bring the human dimension into its work and its will to adjudicate genocide issues in terms of member states' criminal responsibilities and obligations under the 1948 Genocide Convention. Plus, in the last few years, the court has seen also an increase of judges with strong human rights backgrounds been appointed to its seats. For example, judges such as Higgins, Kojimans, and the later Consider Trinidad have helped bring human rights reasoning, human rights law into the center of the court's work. However, it must be mentioned here, court cannot enforce its member states to comply with the rulings, and there still exists wide spaces of differences between the significance of a ruling to an international framework and to the actual consequences for the people involved in their in the conflict zones and in the fleeing situations. As you can see, the court's 1993 Bosnia and Herzegovina versus Serbia and Montenegro ruling was not able to stop the Srebrenica massacres in 1995. And several rulings cases, such as Croatia versus Serbia in 1999, also have revealed some shortcomings, such as errors of procedures in the court's work to ensure high quality of the court's work. Secondly, from a political perspective, the court's Bosnian and Herzegovina versus Serbian rulings has marked several landmark rulings. As mentioned, the court with these rulings is ready to commit itself to the same essential task faced by the Yugoslavia tribunal. Meanwhile, critics emerge concerning the question if Serbian under Milosevic's leadership has incited the Bosnian Serbs leaders who have committed the genocide acts. Some have raised the concern if the political consideration of prospective EU membership might have played a role in the court's ruling. And in this place, it is also worth mentioning here that in May 2024, this year, the UN General Assembly has passed a resolution on Srebrenica genocide and introduced the 11th July as International Day of Reflection and Commemoration. Although many have decried the politicized nature of the resolution text, it appears that the court's rulings in 2027 also have a strong political effect upon the UN General Assembly's move to pass such a resolution. Thirdly, as part of my first argument, reflecting upon the relationship between the ICJ and ad hoc international criminal tribunals, the first important thing is that all tribunals and court activities must observe the principles of judicial independence and impartiality found in the Article 38 of the Statutes of the Court. However, the work of extraordinary chambers in the Court of Cambodia has shown that the ambivalence of the double ownership in such hybrid courts, and including the question of personal jurisdiction as well as the maintenance of international standards. And the work of the, moreover, the work of the ad hoc tribunals for Yugoslavia and Rwanda has demonstrated that adjudicating genocide issues present several unique interpretative and analytical challenges, as George has already mentioned. The court, intended as a forum to resolve disputes between states, is ill-equipped to adjudicate those issues. And then probably, nonetheless, I would say the court's recent provisional major rulings, as we will later hear from Jennifer's as well as Chip's presentation, the court's recent activities has shown its willingness to bring into its deliberation efforts the court's experiences found in those ad hoc tribunals and national courts. Such steps have implicated that the court will increasingly need bottom-up impulses while tackling those difficult issues such as the definition of a specific intent in genocidal issues and the inclusion of victims' voices. In fact, the experience of past and recent ad hoc tribunals and national courts have demonstrated the emergence of a tendency to include a more victim-centered approach, which would allow the court not to betray the spirit of jus gentium. A larger involvement for victims, of course, is practically not impossible. Nonetheless, the European Convention of Human Rights illustrates that since it not only recognizes a right to effective remedy, but also allows individual applicants' compliance bring in front of the court. This practice has already become part of a national laws framework. For instance, in France, the victims can choose choose to institute a case as partie civile. They will argue for reparation of their damage and be kept aware of the process of the trial, and thereby ensuring the victim's participation during the whole process. In that sense, the court can get inspired by such experiences and revisit the opportunity to grant relief that might have gone further toward the protection of rights at issue. I stop here. Thank you.
Thank you, Dr. Hasenkamp. And I'd like to remind everybody to please put your questions in the Q&A function. You'll find the link to it or the icon for it down at the bottom of your screen. Our next panelist is Dr. Jennifer Davis. Dr. Davis is an associate professor in the Intelligence Analyst Program at James Madison University. She has subject matter expertise in international criminal law, particularly genocide and war crimes, and also researches women's and children's human rights and the impact of disruptive emerging technology on human rights. She will be speaking about the political and judicial issues at stake, particularly as related to Russia and Ukraine. Dr. Davis?
Good afternoon. Thank you for the introduction. So today, as stated, I'm going to be talking about two recent cases before the ICJ concerning genocide. First is Ukraine versus the Russian Federation, initiated by Ukraine on February 26, 2022. The second is the case initiated by South Africa against Israel on December 29, 2023. So for today, I am going to be focusing largely on the cases themselves, various state positions, rulings of the ICJ judges, and the impact, rather than necessarily digging into my own personal opinions about who is right and who is wrong. I'm sure people understand it is, both cases are volatile, shall we say, and there are many, many excellent sources that you can go out and look into some of those other aspects. So while we will be talking some about the impacts of these cases, it's going to be specifically through the international legal prism. So the first case we're going to be exploring is the allegation of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, which is more commonly referred to as Ukraine versus the Russian Federation. It's the formal name of the case. So I am also going to note we're not going to talk other than acknowledging the related case filed by Ukraine in 2017 against the Russian Federation, as these were filed under the International Convention for the Suppression of Financing of Terrorism of December 9th, 1999, and the International Convention on the Elimination of All Forms of Racial Discrimination. And the reason I mention these is because they were part and parcel of the ICJ's February 2024 decision, in addition to the case concerning genocide. But since the panel today is focused on the genocide pieces, I will just briefly acknowledge those, but keep my focus on the genocide-based case. I will note that in the February 2024 decision, the ICJ did reject most of the substantive claims under these and are really keeping the focus narrow on each of these 2017 and 2022 cases. So since Russia invaded Ukraine in February 2022, the two countries have both made allegations of genocide against each other. This case before the ICJ was initially brought by Ukraine to respond to Russian President Vladimir Putin's justification for moving Russian troops into Ukraine. And the reason that this came up is because that was a large part of what Russia used to justify the invasion into the Donbas region, as that they were doing this on behalf of genocide by Ukraine against Russian-speaking inhabitants in the Donbas and other associated oblasts. Ukraine rejects these allegations before the UN's High Court, arguing that Russia fabricated these claims to justify the large-scale military invasion, and that they also had alleged that Russia's invasion itself violated the Genocide Convention, arguing that Russia was attempting to commit genocide against Ukraine and the Ukrainian people. So February 26, 2022, Ukraine filed an application instituting the proceedings against the Russian Federation before the International Court of Justice concerning a dispute relating to the interpretation, application, and fulfillment of the 1948 Genocide Convention, Convention on the Prevention and Punishment of the Crime of Genocide. So Ukraine contends, inter alia, that the Russian Federation falsely claimed that acts of genocide have occurred in Luhansk and Donetsk oblasts of Ukraine, and that on the basis recognizing the so-called Donetsk People's Republic and Luhansk People's Republic, and then declaring the special military operation, using this as grounds for the invasion. Ukraine emphatically denies that such genocide has occurred and submitted in its application to the court to establish that Russia has no lawful basis to take action in and against Ukraine for the purpose of preventing and punishing any purported genocide. And then Again, as I mentioned, Ukraine also alleges that the Russian Federation was planning acts of genocide in Ukraine and intentionally killing and inflicting injuries on members of the Ukrainian nationality under Actus Reus of Genocide, Article 2 of the Genocide Convention. So moving forward a little, looking at these, there were initial hearings on March 7th, 2022 in The Hague, the Netherlands, to determine immediate action and Ukraine's entitlement to provisional relief. At that particular hearing, the Russian delegation did not appear, but they submitted a written statement. On March 16th, 2022, the court did rule by a vote of 13-2 that Russia needed to immediately suspend military operations in Ukraine while the case was playing out, while waiting for the final decision on the case. So that has not happened. The special military operation that Russia calls the Donbass invasion is continuing. There are 4 oblasts included. I'm sure people are well aware of the news. And so this is one of the themes that I'll be coming to after discussing the next case, is that the ICJ has the ability to issue hearings, but does not have any other means of enforcing them. They do rely in particular on member states to enforce this. And so we're going to see a common theme that even when the ICJ issues rulings ordering states to put on indefinite pause any military operations and cease military activities, that often doesn't happen in reality. And that's not happening in either case. So going on June 9th, 2023, the ICJ accepted requests from 32 countries to back Ukraine in their case against Russia, which is to date still the largest number of countries to join on a particular side of another nation's complaint at the World Court. Originally, the United States did attempt to join this as well, bringing the potential number to 33, but because they had not accepted a particular part of the Genocide Convention when they ratified, the ICJ rejected the United States' position, but did accept petitions from 32 other members in support of Ukraine. On February 2nd of 2024, the ICJ issued a ruling that it does have jurisdiction, but only over certain very narrowly focused aspects of the case of Ukraine versus the Russian Federation. Per that ruling on February 2nd, in addition to the others that I mentioned at the start, the ICJ determined there were 2 core aspects to the dispute between Ukraine and Russia. The first of which is Ukraine's submission that no genocide attributable to it has been committed in the Donbass region. And the second was Ukraine's submission related to the compatibility of the Russian Federation's actions with the Genocide Convention, basically saying that Russia was the one that had violated the Genocide Convention and not Ukraine. What the ICJ ruled is that it would consider the first of these. It would consider the original claim by Russia that Ukraine had violated the Genocide Convention in the Donbass region. This is the first aspect of the dispute. In its judgment, the ICJ unanimously dismissed Russia's procedural objections, ruling that the court did have ability and jurisdiction to decide on the merits of whether Ukraine is responsible for committing genocide in the Donetsk and Luhansk regions in violation of the Genocide Convention. However, the court also determined that it would not rule on Ukraine's claims that Russia's invasion itself violated the Genocide Convention, which was the second aspect of the original proceedings. In the ruling, ICJ President Joan Donoghue wrote, "In the present case, even if it were shown that the Russian Federation had invoked the convention abusively, which is not established at this stage, it would not follow that it had violated its own obligations under the convention, and in particular, it had disregarded the obligations under Articles 1 and 4. So that was ultimately a 12-4 vote, looking specifically at the original aspect of whether or not Ukraine is committing genocide against Russian-speaking populations in the Donbass, not the second part of Ukraine's initial appeal that Russia itself was in violation of the genocide. And they kept that focus very narrow, which brings us to our second recent case under the ICJ, the application of the Convention on the Prevention and Punishment of the crime of genocide in the Gaza Strip, which is more commonly known as South Africa versus Israel. So this is a much more recent case. It's not quite a year old, that was brought to the International Court of Justice by South Africa on December 29th, 2023, regarding Israel's conduct in the Gaza Strip during the Israel-Hamas war and the results of the military action. So the underlying legal argument here is based upon the same logic and the same statutes that the Gambia brought against Myanmar, Burma, that my colleague George already discussed. So they're using, the same provisions and the same case law that the Gambia did when accusing the Burmese government of committing genocide in Myanmar. The South African government is using the same underlying logic and the same case law to bring case charges of genocide against the government of Israel. So in their claim, South Africa alleged that Israel has committed and is continuing to commit genocide against Palestinians in the Gaza Strip in violation of the Geneva Convention, both in the current Israel-Hamas war that began from October 7th, 2023, but also including actions going back about 75 years. There's a series of claims of genocide that South Africa has brought to the ICJ against Israel. So South Africa requested that the ICJ indicate provisional measures of protection, including the immediate suspension of Israel's operation. Israel has responded that South Africa's charges are not legitimate and arguing that they are conducting a war of self-defense in accordance with international law following the Hamas attack on October 7th, 2023. So there have been so far 2 days of public hearings held on 11th and 12th of January this year, 2024 in The Hague. The court did issue an order very similar to its order in the Ukraine-Russia case, encouraging Israel to take all measures to prevent any acts contrary to the 1948 Genocide Convention. However, unlike in the Ukraine-Russia case, the court did not order Israel to suspend its military campaign, as they did order Russia to suspend that military campaign in the Donbass. The courts did express concern additionally about the fate of the hostages held in the Gaza Strip and recognized the catastrophic humanitarian situation in Gaza. So that brings us to March 28th, 2024, following a second request for additional measures. The ICJ ordered new emergency measures, ordering Israel to ensure basic food access, food supplies without delay due to risk of famine and starvation. And on May 24th, by 13 votes to 2, the court ordered an immediate halt to Israel's offensive in Rafah. So that largely brings us to date. In terms of support, it's a bit more mixed. So it is just shy at present of the states who have filed in support of Ukraine. Right now, South Africa's case has been supported by a total of 31 state parties. And that number may change as the case goes forward. It's a more recent case, but as of present, it's 31. Ukraine had 32. So right now there's a difference of one state in terms of support for the two countries bringing the cases forward. In the South Africa versus Israel case, 12 countries have filed applications opposed to the case. So the most number of state parties total, but on different sides of the equation. So in quick summary, before we move to the next speaker, as with any case concerning genocide, one of the toughest things for any court to determine is intent. So many of these cases do hinge upon the intent of the state party. In order to be a violation, there has to be intent in whole or in part to target another group. And so since Nuremberg and Tokyo, this has gotten more and more challenging, I think, for courts to be able to clearly prove, just because I think potential and alleged perpetrators of genocide have gotten better and better about masking intent and making it difficult to prove whether or not that intent exists, because that intent is so important in the definition. So I do think one takeaway is that both of these cases serve to highlight potential weaknesses in ICJ's ability to manage cases concerning genocide, and in particular, the lack of enforcement that they have. The ICJ does not have an enforcement mechanism on its own. They have to rely on other state parties and other states to enforce. All they can do is issue opinions. And what we've seen so far is that at this point, states are not following the orders of the ICJ to date. And so whether or not, I think that brings up a larger debate about the impact of international criminal law and whether or not international criminal law matters or not. It's a very popular debate. With that, I will leave it up to you all to decide based on the outcome of these decisions and pass it over to my next speaker. Thank you.
Thank you, Dr. Davis. And just a reminder, please submit your questions in the Q&A feature. You will find the icon at the bottom of your screen. It's right next to the share, right to the right of the share icon. Our fourth panelist is Dr. Chip Carey. Dr. Carey is Associate Professor of Political Science at Georgia State University, as well as editor of the Journal of International Organization and the outgoing chair of the International Study Association's International Law section. He has written extensively on human rights, international prosecutions, and his most recent book is Legalization of International Law and Politics, which he co-authored with Dr. Stacy Mitchell. Dr. Carey will be talking about reservations to jurisdiction of the ICJ, as well as the Gaza cases. Dr. Carey?
Thank you very much, Kathy, and to my colleagues for their excellent comments. I have 8 quick points, which in 12 minutes comes out to something like 90 or less, fewer seconds per point. But I think they're all refer to this general introduction that Kathy gave about jurisdictional implications of the increasing jurisprudence and litigation before the International Court of Justice on genocide. My first point is there's good news and bad news about this expanding activity. The Genocide Convention allows the International Court of Justice to transcend otherwise impose exclusions of compulsory jurisdiction for litigation before the ICJ and all other matters, except perhaps treaties that also give original jurisdiction, such as the Torture Convention and arguably maybe the Race and Apartheid Conventions. My problem here is that this burgeoning litigation with 4 major cases ongoing at the moment, potentially, depending on how you distinguish basically direct and legally binding cases with advisory opinions, is that we're only so far looking at genocide and not combining, let's say, with torture. The consequence of this is that whatever the probability of a guilty verdict, and the probability is very, very low for a number of reasons that I will quickly discuss, it is that if you are found not guilty of genocide, even though provisional measures to prevent and punish genocide have been issued, and that seems to be the pattern, everybody's going to be disappointed, both plaintiff and respondent, people who say, okay, we're not guilty of genocide, but we're committing atrocious crimes against humanity, war crimes, and other international crimes that ought to be punished. But the ICJ is only empowered, at least in these particular cases, to punish genocide. So, for example, Israel, under the current law, in my opinion, there's absolutely no case of genocidal intent or the exclusive of a military motive. And most of the litigation so far has been that the motive is not just primarily racial, religious, or national hatred and targeting, but no military motive for the shooting. And so by that standard, there's no situation, there are hardly any situations, given the social science empirical data, that almost, if not all, known genocides occurred during armed conflict. So in armed conflict, you're always going to have a military motive for shooting the other side. And then you've got the ambiguity of provisional measures seeming to contradict the verdict. You also have lots of other ambiguities that I'll allude to so far. Second point, we now have the good news that 2/3 of the world's countries have ratified the Genocide Convention, minus 16, it may be a few more, that have maintained their Article 9 reservation on jurisdiction on the Genocide Convention. But that means 137 countries from the 153 that had ratified the convention at the end of the last year have not have an Article 9 restriction on jurisdiction, roughly 2/3 of the world's countries. That leaves lots of countries where the situation, certainly in raw numbers, are worse than Gaza and Russia. Granted, those are recent wars, or at least the intensification of the Russian war in Ukraine is only 2.5 years old, and we're not even at a year exactly in the Gaza conflict. But notwithstanding that, we have wars in Sudan involving the Janjaweed militia, now the RSF taking over for them. That particular war, we have alleged genocidal activities by both sides. Of course, state parties can only be held to account, but Sudan is not the subject of an active genocide case at the ICJ. The ICC may hold individuals, but we don't have states. Palestine has been a state party to the Genocide Convention since 2014. Palestine is not Hamas, perhaps, but the government of Palestine is like East and West Pakistan up to 1971, a geographically separated territory. There is theoretically, in legal terms, maybe not in social science terms, but in legal terms, there's one state, and it is Palestine. Why is Palestine not being pursued for October 7? There is an obligation not only not to perpetrate genocide, but there's also an obligation to prevent genocide. And once you open the gates under the Genocide Convention to holding trials on failure to prevent genocide, you allow governments like the United States, just to cite one obvious example, of allegedly giving arms to groups around the world, whether they're terrorists or states or both, or indirect relationships, of failing to prevent genocide. We can also say that this gap between provisional measures and verdict is going to be very, very hard to reconcile legally, and certainly not politically. And I think in almost all of these cases, you're going to get provisionals within 4 weeks, as has happened so frequently so far, and then verdicts 5 years later, which will hardly have an impact, and the verdicts will be not guilty. And the reason it'll be not guilty is the coexistence of military motives and genocidal speaking. You have lots of additional problems here. These are not criminal trials. They involve the crime of genocide from the Genocide Convention. But at least under orthodox interpretations, a state suing another state is what Americans and common law countries would call a civil trial, where you're looking for injunctions and orders from the court and maybe reparations, perhaps, but you're not punishing the state formally and putting the state in prison. Now, in the United States, we do have Arthur Andersen and other corporations suddenly becoming held criminally liable for fraud, for criminal fraud, and maybe international law will change to hold states criminally liable. At least the orthodox jurisprudential interpretation of this ICJ litigation is that these are not criminal trials. Therefore, maybe that means that the mental element will not be proof beyond a reasonable doubt that there was a genocidal intent, but the preponderance of evidence. The jurisprudence hasn't moved in that direction so far, but if it is a civil trial, then presumably the standard of proof is less. And then you might be able to get over some of these vagaries, like maybe 3 or 4 cabinet members of the Israeli government clearly expressing genocidal intent, but the government never makes it official policy. And so you can't prove beyond a reasonable doubt that the government of Israel is deliberately targeting and being motivated by the desire to kill Gazans or Palestinians, whatever the racial label is implied, for hatred reasons and hostility reasons, which is the essence of this kind of prejudice that is at the core of genocide. And this is partly because the Genocide Convention was written in the context of World War II and the Holocaust specifically, and the Holocaust is really an exceptional genocide. Most genocides are counterinsurgencies and armed conflict that result from death marches, starvation, yes, the odd shootings of people here and there, but not Auschwitz, not firing squads on the Eastern Front earlier in World War II. Those events happened, but as we can see in the Bosnian case with Serbia, that Serbia was held liable for failure to prevent genocide, but there was only this act of genocide at Srebrenica, for which was explicitly nominated in that case as genocidal. But then we get into the problem, are we distinguishing genocide in general or acts of genocide, a legal term of art that's come out of the litigation prosecuting individuals at the ICC and the ICTY and the ICTR. We don't have this distinction certainly clearly marked out. Does the ICJ's jurisdiction under the Genocide Convention incorporate this international criminal justice principle of acts of genocide as opposed to genocidal policies? We also have, fourthly, this ambiguity on countermeasures in international law generally. We don't know whether two wrongs make a right in international law generally. We have the ILC doctrines of state responsibility, which seem to maybe contradict the Geneva Conventions on the legality of illegal acts in response to illegal acts if they do indeed deter and reduce the original illegal acts. But then you open up a host of other questions if you do permit two wrongs making a right. For example, is October 7th the definitive date for which Israel, if it's allowed to have countermeasures and do illegal things because they're deterring the original illegal things, is October 7th the operative date or 1948? It's really hard to say. Generally, in political discourse, we look at October 7th as a really important date, but that it could be that, the Palestinians would argue, or whoever would argue if they were in the dock, that we need to go back further in time. I would say that the Gaza situation is also really impactful in the current non-legally binding advisory opinion case on the occupied territories, which was issued in July. That is given by the same set of judges who presumably believe that customary international law not only concluded that Israel's occupation of the West Bank and the Gaza Strip, and presumably earlier, the Sinai Peninsula, which incidentally did succeed in having a land for peace solution with Egypt, a very ambiguous peace, I suppose, if you oppose the blockade of Gaza, but created peace between Israel and Egypt. And so one cannot say definitively, and certainly not proof beyond a reasonable doubt, that the land for peace formula is not present in Israel's occupation of the West Bank, and for that matter, the Gaza Strip, which it currently, I suppose, occupies, but theoretically, when it withdrew a little bit over a decade for a while in Gaza, they were not occupying it, even though they were blockading it along with Egypt from standard international commerce to some unknown extent. So the Gaza advisory opinion was really remarkable, and its impact on this particular Gaza case and other genocidal cases is really hard to predict. But it is the first time they've explicitly stated that our verdicts are not going to be ambiguous like the genocide verdicts, that occupation is clearly illegal, in spite of the fact, in this case, we have a precedent of Egypt and Israel taking an occupied territory and giving it back and making a peace agreement. And regardless of how ambiguous you look at that relationship, non-armed conflict is a lot preferable than armed conflict when genocides take place, and for that matter, crimes against humanity and war crimes. Finally, I would say that the failure to prevent genocide is the big gap. We only have the Bosnia versus Serbia case on failure to prevent genocide, but it is really basically only the situation of the state in the zone where war is and genocide is allegedly taking place, where this has been applied. or right next door with the same ethnic group. So I've gone over my time, and I do want to just point out that if you're talking about material support for genocide not being failure to prevent genocide, that's a great shortcoming in this litigation and jurisprudence, because providing the arms in these counterinsurgencies in what are most wars in the world, 95 or more percent are civil wars, but these civil wars all have this international dimension of not just arms, but aid, and for that matter, humanitarian relief being given and stolen. We should be reminded that the Bosnian genocide occurred in the context of well over, by most estimates, 2 times the humanitarian relief that was required to keep people alive. And yet, with 2 times or 3 times the amount of humanitarian relief being given there, it was diverted, first of all, by the governments in charge, and corrupted, obviously, by the leaders to line their pockets, rather than getting the aid in because it was too dangerous to let NGOs distribute it in a neutral manner. And that would be hard enough in the best of circumstances. Thank you very much.
Thank you, Dr. Carey. Again, a reminder, please enter your questions in the quick Q&A function, the icon for which you will find at the bottom of your screen. Our final panelist is Dr. Henry Lovat. Dr. Lovat is lecturer in international law and politics at the University of Glasgow. His work focuses on the politics of international courts across various fields, ranging from criminal to trade law. Dr. Lovat will speak to the techniques that the court has used to steer through the often fraught politics of genocide cases, discussing both history and recent cases. Dr. Lovat?
Very kind. Thank you, Kathy. I'll try and keep this super brief. Thank you for organizing this and for having me on. Stefan Talmon recently referred to as being in an era of genocide fear, referring to disputed cases and the ICJ genocide cases having risen in political salience. And that provides a really nice way of capturing the very fraught politics and political circumstances in which the ICJ finds itself and the context it needs to navigate. So let's set that aside for a moment. Talmon has also observed, as he put it, the methodology is probably not the strong point of the International Court of Justice, or indeed of international law in general. Now, that can be taken to mean a few things, but inter alia, I think even though we see this as a court, we have to bear in mind it's also a political institution. It exists in politics, it navigates situations politically, strategically, you might say, more or less effectively. Let's say reflecting the preferences of its different constituents at different times. That leads to a really interesting observation in turn, that in many cases, or many actors, the ICJ is seen as a reverse mirror, if you like. For some, it is seen as a horribly, dastardly, conservative, insufficiently activist body. For others, it is seen as unsustainably radical and, terribly progressive. The actual fact is that the court kind of navigates between these two poles that most courts do, international and domestic. And although there's no equivalent in the ICJ jurisprudence to the doctrine of, let's see what's called, essentially political acts, let's say, where the ICJ will defer to political actors, the ICJ has developed what are typically called avoidance techniques to deal with politically sensitive issues. So that's to say the ICJ very rarely, in fact never that I'm aware of, turns down a case that has legal aspects. We'll never say, no, we won't hear this legally fascinating case. It can say this case has no legally relevant aspects, but that's incredibly rare because it's international courts, it wants the cases. But it is also aware that a lot of it is politically sensitive. Therefore, it has developed over time and utilized a series of what we call avoidance techniques. These can be, for example, classically is find there's no dispute in a case. The classic example of that is the old 1970s nuclear weapons cases, where although a case had been brought by Australia against France, on the basis of a French unilateral undertaking, the ICJ then thankfully stepped back and said, well, you don't have to decide this. There's no more dispute. The matter is resolved. It could deny standing, so a party bringing a dispute, which we'll talk about in a minute. It can use judicial economy, try to write less rather than more, create fewer hostages of fortune. It can reframe legal questions. It can use technical grounds. It can say it doesn't have jurisdiction, although that's rare. But we do see that where there are other courts concerned. And it can use a more or less deferential standard of review to acknowledge the, in CHR language, margin appreciation of the actors involved. So no doctrinal deference to political actors and political matters, but these so-called jurisprudential avoidance techniques that are available to the court. Now, let's put all that in the context of genocide cases. So we know that the court cannot refuse to admit legal character of cases involving, let's say, actual legal issues. But we do know that genocide provides also a fairly easy mechanism for disgruntled parties to bring cases before the court, the applications. And we also know that it carries a particular stigma. So there are incentives stacked to bring, there are strong incentives to bring these cases for different actors. Whether you are Gambia, whether you are Bosnia, whether you are South Africa, and all the rest. So easy access, high stigma, strong incentive on actors to bring cases. But for the same reason, these are also particularly fraught cases, which means the court finds itself in quite challenging waters sometimes. The classic example in the context of genocide cases where we see the avoidance techniques in use is the contrast between the Bosnian and Croatian genocide applications in the 90s and the subsequent late 90s, late 99, I think, application by Serbia and Montenegro against the NATO states, where the issue was use of force, and Serbia and Montenegro also invoked the Genocide Convention Article 9. Now, the problem was, in these cases, I'm sure everybody knows, in the Serbian and Montenegro versus NATO cases, the court found it had no jurisdiction. It found that Serbia and Montenegro had no standing because they were not a UN member state at that point, could not bring the case. Fine. That seems a very clear avoidance technique to avoid having these, let's say, powerful Western states in the firing line of a contentious ICJ case. Excellent. That makes common sense. But that then, of course, put the court in a bind when it came to genocide cases from Bosnia and Croatia. Because if you've decided that the former Yugoslavia, as it were, Serbia and Montenegro, is not a UN member state and can't bring a case under a genocide convention, how then can it be liable under the same convention? So, illustrating that, as Tom puts it, methodology is perhaps not its strong suit, the court in these cases simply said, well, res judicata. They already decided this before the 99 cases, therefore it doesn't matter. Now, lawyers have been having a field day with that jurisprudence for years, trying to parse out how it can possibly make sense, it's an inconsistency, And the fact is, the sense that I've picked up from reading the critiques and sort of the commentary is that it is actually an inconsistency in the jurisprudence. It's very difficult to square this any other way. But, as one commentator has put it, given the overall procedural and political circumstances prevailing in that case, this is the Bosnia case at the time, the court in 2007 had no other option than to reaffirm its jurisdiction and proceed to deciding the merits of the case. In other words, regardless of the sort of, but one hesitates to say politics beats law. But I suspect there's an element of that in the ICJ's work in all its cases, and perhaps also in genocide cases. Another quotation from 2017 from, I forget who this was, although none of the court's decisions were totally beyond the bounds of judicial propriety. What is visible is a trend where the court sought to decide cases any way that best fit the political situation at the time. This is also consistent, of course, with Carlo da Ponte's observation that in the same fact pattern, this is the issue of the ICTY jurisdiction over NATO countries, that she faced coming up against the boundaries of the political universe which the ICTY was permitted to operate. So let's then take that. We know the court applies these avoidance techniques in genocide cases. Say, okay, given the cases in front of it at the moment, how might this all play out? The interesting case here to flag is Gambia, Myanmar. In Gambia, Myanmar, the court arguably set a very low bar for provisional measures. Erga omnes, obligations, standing, and this is a dispute, very minimal evidence. That means that in future cases where the Genocide Convention is in play, the threshold for any provisional measures application is going to be low. That means we're arguably likely to see even more cases and more situations where the court finds some of these difficult situations. Ukraine v. Russia, we've seen the court order provisional measures that were completely ineffective, made no difference in the ground. In the Gambia case, as we know, provisional measures there simply effectively restated Myanmar's obligations in any case of the Genocide Convention, don't commit genocide. And we see the same thing in South Africa versus Israel, where the extent of the substantial extent, if you like, of provisional measures say do not commit genocide, which Israel says, thank you very much, we're not, that's wonderful, we'll keep going. Now, we do not know how this will play out at the merits phase, but it seems the case that, number one, we're looking at more cases, difficult situations. Number two, given the, let's say, given the court's inability to decline to take cases, even though politically sensitive, it's going to be a struggle anyway to find appropriate avoidance techniques increasingly. The question then is, what does that imply for the court itself? Are we looking at a situation where the court is going to struggle increasingly to navigate, let's say, the legitimacy issues, where it needs to make judicially competent, persuasive, legitimate decisions without pissing off anybody important too much? And one gets a sense, reading the cases, and with the genocide cases at the very forefront here, that there are some increasingly challenging political challenges, say that, facing the ICJ. Thank you, Kathy.
Thank you very much, Dr. Lovat. And that concludes our panelists. We have one question in the Q&A section. I'm going to paraphrase it a little bit to go a little bit closer to what Dr. Lovat said. So since the court is having so much trouble and getting more and more difficult cases and having trouble handling these political cases, what do you see as the court's ability to actually be able to resolve, enforce prevention of genocide? And is this something where maybe a more diplomatic response is necessary, or even an arbitration or mediation type response needs to be forced?
Is that to me, Kathy?
Yeah, any one of the panelists. Yeah, go ahead.
I'm happy to jump in on that one. The court doesn't like turning down cases, even when it's obviously really poorly placed to have any effect or impact on the outcomes. So, you know, it depends who's on the bench. I think Sebutinde said already that this is not, the South Africa Israel case is not one that the court should be hearing. She said the same thing about the advisory opinion, and yet it does. The risk, of course, that leads to let's say, impairment of the ICJ's reputation. And that is hazardous. You know, the risk of, paraphrase again, the risk of pursuing justice, even if the heavens might fall, is that sometimes the heavens do actually fall, and they make future justice even less likely and much more challenging.
Would anybody else like to add to that? Any of the other panelists? Dr. Andreopoulos?
Yeah, let me address this. And first, let me focus specifically on the question of part of the question that the attendee raised, Nasir. Why should the United States and ICJ even have jurisdiction over the Israel-Hamas conflict? Well, the United States, the US, does not have jurisdiction, although it is a party that will definitely be involved in this litigation. The ICJ does have jurisdiction. Why? On the basis of Article 9 of the Genocide Convention, where it says that if there are any disputes among states that are parties to a conflict, it is the ICJ that they should go before it to resolve it. And this issue was raised, is always raised when there is some kind of a hearing on, especially on provisional measures, whether a particular state that is filing a suit or not has a standing in order to be able to initiate the case. It was raised in the context of South Africa. It was also raised in the context of Gambia when it tries to bring the case. And the response usually is that genocide is a crime that is considered an offense erga omnes partes, that everybody in the international community is affected by it, and by extension, everybody has a stake in it, and everybody can in somehow has a stake in addressing this issue. So that would be the answer to the question that you raised. I want to say also very quickly something about something that Henry mentioned about lowering the bar in provisional. In some cases, yes. In some other cases, I think the evidence presented was pretty strong for provisional measures. However, I do see a pattern here. But of course, we'll have to wait and see to what extent this will indeed prove to be a pattern. That given actually the importance of genocides, consider the crime of crimes, and that it is very difficult to turn down cases of genocide. It will not look good in the court's reputation. What it seems to be doing is that it is making easy the entrance to the proceedings is made easier by ordering routinely provisional measures. But then the difficulty emerges when it comes to the merits case, when you did find a finding for the for example, that the special intent has been the criterion of the existence of the special intent dolus specialis has been satisfied. So I think an argument can be made, but a very tentative one, that the court does try to have it both ways, letting people in, letting applicants in to at least appear as if it is taking this issue easily, but realizing the political ramifications of a finding that genocide has been committed, being extremely parsimonious on the merits case. I would argue that this is the trend that we are seeing. And if I have to guess, and of course we should not be guessing because very often the predictions are proven false, I think from the pending cases, taking geopolitical considerations into play, and the status of the countries that are responding in these cases, if we were to find a finding and I will be happy to elaborate if somebody wants me to do, if we're to find the finding of the commission of genocide in the merits phase, if there is one case that I can see this most likely, will be the case of Burma, more than any other case. And I'll be happy to elaborate the reasons for this. But that's the only one that I could see there might be a good chance of issuing a finding of genocide on the merits phase. Thank you.
I had a response as well, quickly. I want to emphasize that the court is not unique in not being able to enforce its measures. We all know, at least Americans, a certain U.S. president who said the Supreme Court, when he was a general, in the case of, by modern standards, the genocide against the Cherokee Indians in Georgia were sent on a death march to Oklahoma. And Andrew Jackson said, the court has spoken, now let them enforce it. And he was rewarded by getting elected president and founding the U.S. Democratic Party on the basis of that statement in part. But, you know, the UN, the ICJ is a UN agency, in effect. It's an official organ of the UN. That means also all the other organs of the UN that are involved in any of these specific conflicts are also involved in enforcement. So it's not the unique responsibility of enforcement. It's quite possible the Security Council would make a military order to enforce a verdict of the court in the same way that President Eisenhower sent in the National Guard into Little Rock, Arkansas to enforce the principle of the Brown decision on desegregation of schools. I also know that we have so many cases of known genocides, at least according to social scientists, where the court was inactive, even though the states had ratified the convention and not put a reservation on Article 9. Sri Lanka, for example, ratified the convention in 1950. I already mentioned Palestine. The Russia case, you know, at least initiated, as my colleague Jen just stated, over the issue of whether Russia had grounds for intervening on the basis to prevent genocide in eastern Ukraine. It's not clear that that case will really try Russia for its genocidal activities, allegedly, in Ukraine itself against ethnic Ukrainians. But that is at least, you know, part of that litigation, so it may be addressed. Afghanistan, for example, has been a state party since 1956, and it is engaged in basically Sunni terrorism against Shia minorities in Afghanistan, in that country since that time, and certainly since the Russian invasion in 1979. Libya has been a state party since 1989. Gaddafi's words were said to Eastern Libya and different ethnic groups in the East that his Western Libyan regime had a genocidal intent and therefore justified NATO's legal intervention. Of course, it didn't authorize regime change, which is what happened. Iraq has been a state party since 1959. Iraq has, you know, allegedly committed genocide against the Kurds under Saddam Hussein. We've had Shia ethnic cleansing of Sunni after the US invasion. And certainly that's a case, if that's genocide, where the US could also be held to account for collaboration with the regime or criminal negligence and recklessness as far as the mental element of genocidal intent is concerned. Turkey has been a state party since 1950. Turkey has allegedly committed genocide against the Kurds. Uganda since 1995. Idi Amin's activities preceded that, but there have been many such allegations of continuing persecution of its ethnic minorities. Yemen has been a state party, and the list could go on. Yemen has put a reservation, as has Rwanda, 2 state parties, on Article 9, but it doesn't mean an advisory opinion couldn't be issued against those 2 states who are state parties to the Genocide Convention. And of course, advisory opinions, since this is part of customary international law, if not use Kogan's peremptory norms, could be applied to any country in the 193 UN member states.
So we have a follow-up question in the chat, and this goes, I think, to both Dr. Carey and Dr. Andreopoulos. If countries have a common interest in the end of these conflicts, and that's exactly what you were talking about, Dr. Carey, then why don't we create an alliance to retaliate? Wouldn't that be justified? for the reason that ICJ has no way to enforce what they rule. Also, Dr. Andreopoulos, can you elaborate on the specific case?
Well, quickly, just the R2P doctrine already justifies it if the Security Council authorized it legally. If you don't have Security Council authorization from a veto deadlock, then you have the more controversial humanitarian intervention doctrine, which has been accepted by some and rejected by others. But certainly the desire as a purpose of the United Nations for peace and security remains, and genocide is a subset of that category.
Thank you, Dr. Carey. Dr.
Yeah.
Andreopoulos?
I will be happy to respond.
Right.
I see Jennifer's hand up, and Jennifer has not had the chance to say anything. I will be happy to defer to Jennifer, and if there is time, I will be happy to answer the question.
Sure, I'll try to be brief, and it may be that we're saying something a little bit different. So, I think we need to be careful about retaliating. I would say it's more enforcing, because, again, you have to go in with the perspective of the court hearing the case before you start deciding who's right and who's wrong. But I think, as Chip said, there are already some measures, and this was a huge part of why the ICC was stood up in particular, so that it would have more enforcement capabilities. But again, I think the challenge is you are beholden to political will by member states, by the fact that the UN Security Council has 5 permanent members that have a lot of influence and veto capability. And so the mechanics, it would be a great idea, but the mechanics of how to do so always kind of get in the way.
Thank you,
Thank
Dr. Davis.
Yeah.
And Dr. Andreopoulos.
Yeah, very quickly. I would rephrase the question about retaliation. Given the context in which this conversation is unfolding, and when we're talking about protecting human rights and enforcing Rome, and I agree here with Jennifer, the question should be phrased: how can enforce better protection norms as opposed to retaliation? And there is, as Jennifer pointed out, the option of the International Criminal Court if you are thinking in terms of enforcement. Concerning the issue of military enforcement action, here you are opening a Pandora's box. Very interesting question. I don't think we'll have time to address it, but I will be happy to continue the conversation via email with you on that. The only thing I'm going to say, the track record of so-called humanitarian interventions in the 90s and attempts to implement the responsibility to protect a norm that was mentioned, especially in the case of Syria, demonstrated the pitfalls of forcible options in advancing these norms, because you are opening a can of worms, and sometimes the consequences of these actions end up being worse than the problem that you asked to address in the first place when you are contemplating and deciding upon the use of force. So I have to say that the track record is not very good when it comes to that option. Sometimes it created greater problems in the end than the ones that it tried to resolve.
And thank you, Dr. Andreopoulos. And our time is up, unfortunately. As we were talking about in the chat a little bit, I think we have some ideas for our very next webinar. Before we go, I would like to thank our panelists, Dr. Andreopoulos, Dr. Davis, Dr. Lovat, Dr. Hasenkamp, and Dr. Carey. And I would like to thank the International Studies Association, particularly Joel, Sarah, and Kat, and Hannah, for all their wonderful help in making this happen. And thank our wonderful attendees and with their questions and with just being there listening to us. So with that said, thank you, everybody, and we look forward to seeing you in our next webinar. Have a great day.
Thanks
you
all.
all.
Have a great
Thank
one.
you.
Thank
Bye-bye.
you all for coming.